Hello, everybody. Hi, Ava. Ava showed up for her blue buffalo. We got both Earl and Billy in the background, testing out that Marlene's Pet Shop cat bed. Earl just chilling on the couch. Hello, Mortimer Duke. Hello, Iron Mother. Hello, Jerry Matthew Boyd. Hello, Nana Laura. Oh my gosh. That's beautiful. That is absolutely beautiful. Oh my. Some oldies but goodies. We know that. We're very well aware. Ava happens to like you, though. I am not seeing some people. I see people saying hi to people, and they're not showing up in my chat. So, hello, C-Rex. Oh, there you are. There. Hello, Manny. I don't know what happened there. It was not showing me. Like, there's a lot of people I still think I'm missing. Hello, Charlie, honey. I'm sorry. I think we've all got a touch of it. Hello, this is Mia. Welcome back. Ah, that's what we're all saying. I've been complaining for what, a week and a half now. Charlie's been complaining. Jerry's now complaining. Michelle's got COVID. Oh my gosh. We're all sick. All of us. Hello, Salty Buddha, honey. Hello, Eileen and Carlin. Yep, it's the Ava show. We can just, it's just the PAWFURM. I'm not even important anymore at this point. If they could turn on the computer, you guys wouldn't even need me. Hello, Purple Kiv. Hello, Michelle Moreland, honey. I hope you're feeling better. Hello, Spider-Man. You're trolling. You are so trolling. I love you, you dork. Hello, Otto. That's actually a song that I wrote. It's on Spotify and on Apple iTunes. You know what? We haven't listened to it for a little while. Anybody want to hear Methany? Give me a second. It's like 2 minutes of your life you'll never get back. All right, so there's 2 versions of it. I think I even, I put it in a playlist. I did. All right, so no, quit it.
Her house with love and stash. She stays up for days until she crashes. The neighbors speak, unlock their doors when a mighty Methany comes outdoors. She's got 2 nighties before the down, half her gone before they are drowned. Coffee's cold, her eyes still shine. She's a one-woman freak in assembly line. Vacuum running, toast is burning, every thought's a tire turning. Mailman heights, she waves hello.
Don't mind me, I'm Queen Snow.
From 0 to 60, she's always in cheer. The wildest woman you'll ever hear. When the lights go out and the street gets quiet, she's still going up Meth Main Riot. She's mighty Methany, still awake at 4:03. Vacuum running, toast is burning, every thought's a tire turning. Mailman heights, she waves hello.
Don't mind me, I'm Queen Snow.
Neighbors whisper, lock the door, 'cause here comes Mighty Methany once more. She's got 10 new plans before the dawn. She's either cooking or running a gun. Coffee's cold, her green's still wide. She's a cyclone on a sleep inside. She's mighty Methany, still awake at 4:03. When the street goes dark and the night gets quiet, her maniacal love screams, don't even try it. She's mighty Methany, still awake at 4:03. She's mighty Methany, still awake at 4:03. Yeah. Woo!
Okay, so that was the first version. And then give me 1 second here. And then there is a rock version as well.
her hours with her loud mustaches. Stays up for days until she crashes. The neighbors speak and lock the doors. When the mighty, mighty Bethany comes outdoors. Back and running, toast is burning. Never thought that tire turning. Mailman hides, she waves hello. Don't mind me, I'm cleaning stuff. From turn to 60, she's always here. The wildest woman you'll ever hear. When the lights go out and the streets get quiet, she's still going and stop the riot. She's mighty, mighty Bethany. Still waiting for a train. Back and running, toast is burning. Every thought's a tire turning. Mailman hides, she waves hello. Don't mind me, I'm clean as snow. Neighbors whisper and lock the door. Cause here goes Mighty Bethany once more. She's got tender plans before the door. She's in her cookie or running a coin. She's mighty, mighty Bethany. Still waiting for a train. When the streets go dark and the night is quiet, the night of the last screams, don't even try it. She's mighty, mighty Bethany. Still waiting for a train.
Yay! There we go. I had to get myself all back together here. So I'm not that far off with the "Don't mind me, I'm cleaning snow." I'm glad you enjoy it. I know I was quite well chuffed with it. The first version, the music part of it and the singing, well, I did the "Don't mind me, I'm cleaning snow," but the music was done by a guy in, I want to say Argentina. Charlie, is that right? Only if it's yellow. But then we just fling it across the yard. Yeah, the Netherlands was the rock version. And I think it was Argentina for the other one. I would have to go back and look. I hired them on Fiverr. And then I gave them my lyrics. I told them kind of what I wanted. The rock version was done first, and I wanted something that was like universal, and like rock is not, I mean, as much as I love it, and as much as many people here love it, you know, it's not an everybody song, whereas the jazz version, you know, it's more theme song like, which is what I was going for. Oh, I was asking where the guy was that did the second song, because like when I told you, you're like, leave it to them. And yeah, no, it wasn't Brazil. Yeah. Well, I get to tell people I'm world famous. I don't know. I would have to look at my, I think, did I put them on the song themselves? No, of course not. Why would I do that? Oh, well, I think I put it in the Discord. It's in the Discord. Yeah, I had so much fun making that, and it was so hard keeping it a secret from you guys. That was the worst part. I was doing it and I couldn't tell you guys. And then now I have 3 country songs, one of them with 2 versions. And I have the music, like the songs are all done, but I can't put them on Spotify or release the albums until I get the cover art done and possibly even like the music videos for them, because they're actual songs, like not intended for channel purposes, but like intended for, hey, I'm a songwriter. Oh no. Because how many versions of Methany can I make, before somebody says it's too much? We can absolutely make other versions. I mean, they cost a pretty penny a piece, but yeah, so tonight we have a lawyer that is really obnoxious. Always. Every time I have seen this attorney, I have seen everyone around him cringe. Sometimes even his clients. So, you'll get to see Miss Mistily physically recoil and cringe when the man speaks. It's great. It's amazing. And then after that, we get the king of dad jokes. Our absolute favorite dad joke judge.
Hey, Janet,
Yes, sir.
MIDC should, I'm seeing a lot of very high cash bonds being administered by this court. MIDC might want to make some arguments about those bonds.
Well,
reasonableness.
Mr. Williams, when they're being held on a parole hold, that's a different issue. I think I know what I'm doing, but thanks.
No, I don't think you don't. I'm not saying you don't know what you're doing. I'm saying reasonableness isn't excused by parole.
Yeah, I'm aware.
I have this bond issue. I wasn't the attorney when it was set.
Doesn't she look so impressed right now?
Should I call the jail?
No, I think you're getting the last 2. We only have 2 remaining.
All right.
Are you Mr. Dagenstein?
That's me, Your Honor.
On the record, in case number 26-6339 SM, you're appearing for arraignment purposes this afternoon. Mr. Williams, have you filed an appearance in this case?
I don't know if my appearance has made it yet. My office manager has a family member with a medical emergency. So for the record, for the court rule, I will be entering an appearance. And I will place my appearance early on the record.
Thank you. So, Mr. Dagenstein, you're appearing with your attorney, Mr. Williams. Mr. Williams, have you had opportunity to review the allegations on the complaint, nature of the offense, and the possible maximum penalties for your client?
No, that's why I wanted to have a breakout room with them. I want to explain a little bit more in detail. Michael, when it prompts you, go into the breakout room.
So I do have a request of the court. In the future, when we have counsel popping in, if they've not yet talked to their client, given, my time restraints and the fact that I've taken the time to talk to everyone ahead of time, I would ask that I not be bumped. And I'm sitting here waiting so retained counsel can do a breakout with their client.
Yes, ma'am.
They all seem to think I work for the court and that their cases take precedence, and they do not.
Yes, ma'am. So welcome back again.
She's seething. Even when they came back from the breakout room, you could see the tension. Oh my, she's mad.
On the record in case number 26-6339 SM, Mr. Williams, how is it that your client wishes to proceed?
I've discussed the charge with him. He's going to stand mute, ask the court to enter not guilty plea. He will waive a formal reading of the charge.
So the next step in the process, the pretrial conference in this case is going to be scheduled for February 5th, 9:30 a.m. Is that date good for you, Mr. Williams?
Yes, I'll make it work.
Thank you. Information you'd like me to know regarding bond?
Yes, please. So as this court is aware, I believe this court set the bond. He has a pending case that he's still sitting on. It was an felony assault case. He was given a $50,000 cash bond in that case. He comes before the court with no criminal history. I'm not going to argue the reasonableness or unconstitutionality of that bond because we're not here for that today. But because of that bond and because a very large cash bail was imposed without any analysis at all on the record, he's still sitting in jail. He has no criminal record. I've done cases in this county for 20 years. I've represented people on more serious charges than that have personal recognizance bonds. So because he hasn't posted that bond in the other case, I'm asking this court to just impose a $50, not $50,000, a $50 cash bond. Because if he has a PR bond or posts a bond today, in this case, he's not going to get credit. This case would predate, or the allegations in this case that we're here today, I think predate the allegations in the in his other case. So if the court's going to impose anything more than that, I can go into, I guess I'll just address the court if it does. If not, for today's purpose, we would ask the court. The other bond requires GPS tethering, house arrest, 50,000 cash. I mean, it requires, it requires so many things that it would be unreasonable for this court to do anything addition to that. In fact, it may be unreasonable that it's asked for so much already. So, thank you.
You're welcome. So, Mr. Dagenstein, the bond in this misdemeanor case will be a $5,000 10% bond. Conditions on the bond are that you may not use nor possess any alcohol, any illegal substance, any controlled substance, including marijuana, any minor mood altering substances, or any non-prescribed medication. You'll provide a list of your current prescriptions to the district court clerk. You're going to submit 4 times daily PBTs proving you're not drinking. You would have an immediate urine screen and 4 times per month urine screens hereafter. You would also submit to discretionary testing whenever requested by a police officer or any court personnel. You may not refuse. You may not enter a bar, casino, or any place that serves alcohol by the glass. You'll have no contact in any manner whatsoever with Tessa DiMartini. That means no phone calls, no messages through other people, no mail. You may not text message nor through any social network have any contact with her. You will stay 500 yards or more away from her. You may not be at any address that she is or may be. Specifically, you may not return to 568 South Rouge Road. May not use nor possess any weapons of any sort, nor use any object as a weapon. You'll have no threatening, intimidating, harassing, or violent behavior towards any person. You'll be respectful of all court employees and care providers during the course of your case. You may not operate a motor vehicle without a valid driver's license, registration, and insurance, nor with the presence of any alcohol, any illegal substance, or any controlled substance, even that which might be prescribed to you. I am going to place you on a GPS tether. You'll be on home arrest. The release from home arrest would be for verified work, medical appointments, counseling with your attorney, and court appointments. The GPS will be supervised by Community Corrections Pretrial Services, and there will be exclusion zones. Of course, you may not be released until you have that GPS in place and a verified address to give to Community Corrections. So for right now, sir, you are all set. Mr. Williams, you're welcome to file a motion.
Yeah, but
The
hold
bond
on.
is,
Hold on. I want to address this bond. I'm making a record. You're a court. I need to address the court. I want to make a record. First of all, this court imposes cash bail without making any analysis. We don't jump to cash bail. We start with no cash and we work our way to it. This court doesn't make any legal analysis whatsoever. It's unlawful what this court's doing.
you
He already
assisted me
has-
in making the legal analysis, Mr. Williams, and I'm not going to talk over you, so you'll stop talking while I'm talking. Your legal analysis was the same that mine is. He's on a felony bond. The allegations in this complaint may predate the allegations in that complaint. However, it is the same alleged victim. It is an assaultive offense, as well as the felony assaultive crime. There are limited ties to this area. So for those reasons, the bond will be the 5,000, 10%.
Right, but why does he have to have two GPSs? I don't understand. If he has GPS
He
tether,
doesn't have to have two GPSs, he's going to have one GPS,
Right,
but they
but-
will mirror, the bond conditions will mirror each other. So there's no blurring, there's no question. The bond conditions are what they are.
but now it turns into two appeals. Do you understand what I'm saying? You literally have imposed
There's
on a
two
first.
cases, Mr. Williams, for goodness sakes.
I know.
They're
Can I
separate
make?
cases.
Could I make a record without getting interrupted? Would that be okay?
No, maybe not. I'll give you a few more minutes.
You're losing sight that you're imposing bond on a first offense misdemeanor with no prior criminal history. You've lost sight of that.
I have not.
Okay. All right. We're good. We will figure it out.
This is awful bold. Even for this guy. Like, I've every time I've seen Mr. Williams, he has been obnoxious and telling everybody that they don't know their job and that they don't do their job right. It's just it's his MO. Yeah, it's a magistrate, Tammy Rogers. So yeah, he absolutely is shooting himself in the foot. But this is why Attorney Mistley was so short with him. This kind of stuff right here. He does it all the time.
This is considered a serious misdemeanor. It's not presumptive no jail. It's an assaultive offense. I'm not losing sight of any of that. I have done my due diligence as well, Mr. Williams. Thank you, Mr. Degenstein. You are all set.
Thank you.
Good morning, Judge.
Good morning, Martha. How are you?
Good. How about you?
Oh, I'm just Jim Dandy. Just Jim Dandy. All right. Yeah, I've got to do this the opposite because anyways. Oh my God, Irma. Got Irma. Boy to Tanner. Let's see, Irma, what would that be? Annoying. No, not Irma, annoying Tanner. Oh, there's been
Makes sense, Judge.
who hasn't sent me any pictures lately. Hey, so Thursday's our last go, huh, kid?
Yes, Judge.
I don't know, that's gonna be weird. Who's helping you out today? Is that Mr. McGinnis?
It is, Your Honor. Thank you.
You bet. And Mr. McGinnis, do you have anything that you would like to articulate?
I appreciate Your Honor. My client's name are correctly spelled. Will waive a formal reading of the complaints and/or citations. Will stipulate to a factual basis for those entering no contest plea.
Okay, because I can see. So if you're gonna waive it, then you're just gonna go like that.
I think I might use two hands.
How about like this? All right, let's go to Dwayne Bayard. It's 17057. I'm doing this off my phone, so bear with me. Okay, so we've got 2 suspended sentences. Mr. Bayard, you there?
Yes, sir.
Okay.
Good morning.
Good morning. Let me tell you something, sir. You're charged. You're on probation on 2 charges, and you've got a new charge. A plea of guilty or no contest to the new charge may possibly result in your revocation. Do you understand that?
Your Honor, may I speak for a moment?
No, not really. What's the offer, Miss Boites Tanner?
Thank you, Your Honor. If he is willing to plead to the obstructing and resisting an officer, the city would move to dismiss the sitting in line.
Okay, sir. What is your plea to the obstructing and resisting?
I did not resist. Y'all should have it on camera, and I was just properly not guilty.
Okay. Let's then what we're going to do is the bail's going to be set at $500. And did you apply for a legal defender?
Yes, I did.
Okay. Martha, does he qualify? I'm assuming he does.
Let me look.
And if he doesn't, sir, I take it you don't clear over $2,000 a month?
Sir, I would like to speak with you for a moment if we could have the time, the proper amount of time.
Okay, let me ask you something. Do you clear over $2,000 a month?
I'm currently pending SSI.
Okay. We're going to award you a legal defender. We'll get your trial date. It'll be entered of not guilty. City on bail, I've got it already set at 500. Any variance from that?
No, Your Honor, I believe that's appropriate. Thank you.
Okay.
Judge,
Yeah,
Judge, he did not apply for a legal defender.
he did.
No.
Okay, I want you to apply. Get the paperwork from the jail. Just from what I see, I'm going to award you a legal defender. Martha, go ahead, give us a trial date, legal defender information.
Judge, I have February 25th at 1 p.m. with Kathy Burney.
Oh, okay. That doesn't sound like Martha. Sounds like anyways. Okay. Good, sir. We'll see you then. Your bail is $500. You make that bail, report upon release to the Reno Municipal Court, pretrial, bail laws, no drugs or alcohol. Thank you, sir. Okay. Daniel Cruz.
Yes, Your Honor.
All right. You're charged with stalking and resisting an officer. What's your plea?
My plea is not guilty.
Got it. Okay. You're going to retain private counsel?
Yes, sir.
All right. What's the bail suggestion?
Thank you, Your Honor. A moment, please.
Would it be possible to ask for my own recognizance, please?
Well, you can always ask, but doesn't mean you're going to get it.
That's fine. I'd just like to ask. I own my own home outright. I have a business here. I have a fiance that I'm about to get married to. I'm very committed to following through with this process.
Your Honor, on the MPRA, the defendant scores a 7. On the pretrial assessment report, we learned that the defendant states he's been in Washoe County for 6 months, that he has been at this address, at his address for 6 months, and a business owner operated for 4 years. The name of his business is Unicorn Succulents, and he says he's employed full-time by this company. He declined to provide a reference. And the defendant's history was reviewed by the jail, and his score of moderate risk was overwritten due to higher risk based on a history more severe than scored, and I'll go into it. Your Honor, in the probable cause statement, the allegations presented are disturbing. The victim in this case is a school police officer, Officer O'Brien. He reported that the defendant allegedly, since he moved into the neighborhood, has been stalking him and his family, and that's been since October of 2025. The statement indicates that the victim reported that defendant shows up at his house repeatedly, multiple times from 10 p.m. to 4 a.m. And this has been happening since October. He rides his hoverboard in front of the victim's house or drives his car in front of the victim's house. He screams out of his vehicle or from his hoverboard, screams profanities at the home, such as FU, screams the N-word at the home. He screams F police, screams traitor, get out of here. We don't want you in the neighborhood. He does this persistently. The alleged victim reported that him and his wife are terrified and that they live in the home with their 4 young children who are also terrified. When interviewed by police, allegedly, in the probable cause statement, the probable cause statement indicates the defendant stated he would continue to harass the victim and his family if released from jail, as he believed he was doing the right thing.
He sounds like an absolute delight to have for a neighbor.
As far as the obstructing and resisting, it's a non-compliance obstructing and resisting. With regards to his history, Mr. Cruz is 30 years old. His history is as follows, and this is from California: 2014 vandalism, 2017 sending obscene matter to minors. That was a felony, and he was convicted of that in 2017. 2019 possession of images of minor in a sex act. He was convicted of that. Your Honor, based upon the allegations here, the fact that the alleged victim in this case is a law enforcement officer, that he lives in this home with young children and his family, the persistent behavior by the defendant, as alleged in the probable cause statement, my position is that the defendant poses a great risk to the victim and his family. That's also compounded by the criminal history in this case, and also by the high score on the MPRA. I am requesting that you impose cash only bail in this case, $5,000 cash only. If he's able to bail out, that he be required to abide by a no contact order and subject himself to enhanced supervision. Thank you.
Okay. Mr. McGinnis.
Thank you, Your Honor. We request that you make that bondable, not cash only. My client's 30 years old. He said he was born and raised in Northern Nevada, has significant ties. Doesn't appear he has any failures to appear on his criminal record. Again, I believe the city's met its burden for a monetary bill based on the allegations in this case.
All right, Mr. Cruz, I'm going to impose a $7,500 cash only bail. When you make that bail, report upon release to the Reno Municipal Court. Pretrial conditions, you'll be placed on enhanced supervision, obey all laws, and no contact in any regard with Scott O'Brien at the Skyline View Drive. Don't contact him directly. Don't contact
I won't even
him.
drive by his house.
Don't contact him directly. Don't contact him indirectly. Don't have any friends contact him. Any contact from you or friends associated with you will be a violation of your bail conditions, and you'll go back to jail. Okay, Martha, let's get him a trial date.
His trial date is set for February 18th at 1 o'clock.
All right, thank you. Nathan Barnard, did we?
Oh yeah, I love Judge Draculich. They were asking for $5,000 cash bond, and he's like, no, we're gonna do 7,500. Oh, he wanted to say so much more, but there's a good jailer in there today that keeps telling these guys to zip it.
Do that already? No. Okay, Nathan Barnard. Looks like we've got, okay. What's the city's offer on Mr. Barnard?
Your Honor, I don't have anything to offer him. He's got 2 cases, hit and run and no insurance. So he's got to plead to both of those. And then that's a hit and run from 2024. And then he's got the new case that brings him in custody, and that's a target trespass.
Okay, we're going to combine these. What's the, Mr. Barnard, are you there?
Yes, I'm here, Your Honor.
Okay, on 15850, what's your plea to the hit and run?
Guilty.
Okay, what's your plea to no insurance?
Not guilty.
Okay. Then we're going to combine those. We're going to set that as a not guilty.
Hey, Your Honor, I think Mr. Barnard needs to enter a guilty plea to both those. We've had this conversation. He says he has proof of insurance from 2024. He'll be able to cure it at a later date.
Okay, yeah, if you do this is what we do. I impose a fine, and then I say you report upon release to the Reno Municipal Court, and I give you a certain number of days to provide proof. If it's like no insurance, if you plead guilty, it'll be a $743 fine. If you report to the court and within 45 days you provide insurance that you're insured before that date, it's going to be dismissed or else your fine is reduced. Do you follow me?
I do, Your Honor.
Okay, so what's your plea to no insurance?
Not guilty.
Okay, let's try this one again. If you plead guilty to it, what you'll do is you'll go down to the Reno.
I plead guilty, Your Honor, sorry.
There we go. And do you admit failing to appear on January 7th of last year?
Yes, I do.
Okay, how long you been in jail?
Less than 24 hours.
Okay, I'm going to give you time served on the failure to appear. Now, just to deal with this one here, on the hit and run, I'm sorry, what's the city's suggestion on hit and run?
Your Honor, we need a restitution hearing. So we have a victim out there, an uninsured accident. I'm going to ask the defendant remain in custody. So that way he can be sentenced after we contact the victim and see if the victim has a restitution request.
Is it too soon to do it tomorrow?
Your
Yes.
Honor?
Yes, Your Honor, this case is old, 2024. We need a little bit of time to try to get in touch with this victim.
Okay, we're going to continue the sentencing until next Monday. That give the city enough time?
Yes.
Okay, the sentencing will be next
Judge.
Monday. Yeah,
Judge, I'm sorry, we can't do it next Monday.
next Tuesday. Yeah, because Monday's a holiday. Okay, and what I'm going to do on that one, sir, is Irma, is there a problem with doing an OR and having him report? Well, he's already got an FTA.
Your Honor, if I may, just for a moment, have a moment. So he indicates he has insurance from 2024, which I think is going to be significant in this case. I recognize he has that failure to appear, but if he's able to bring insurance to the sentencing, 2 things can happen. The victim can file a claim, plus the insurance charge can be dismissed.
That's true. Let's do this then. I'm going to give you an OR release on that. We're going to do, Martha, can we set up Monday for the sentencing?
No, Judge, we can't do it next week.
Okay. Give me a date on that then.
So it's gonna be out of custody?
Yeah, it's going to be out of custody.
Irma, are we looking like 20 days out?
Since we're doing it out of custody, I would prefer 30.
Okay,
Thank you.
you're welcome.
Okay, while we're looking, okay, go ahead. I'll just wait for you, Martha.
We can do February 18th at 1 o'clock.
All right, so now you show up February 18th at that time. Bring proof of your insurance.
Oh.
And then they'll address they'll address the hit and run. Okay, now in a separate case, you charged with trespassing on January 13th. What's your plea?
Guilty.
All right, city.
Your Honor, would it be prudent to also set
Let's do
sentencing
this
on
then. We're
the
gonna
case?
we're gonna combine these cases. So when you show up for your hit and run matter, it'll all combined with that case will be the trespass case. Do you understand?
I do, Your Honor. Thank you.
Okay, now stay out of trouble. Make sure you show up on that date.
Gotcha.
Thank you.
Appreciate it.
You betcha. Okay, let's go to, we did Jorge Vasquez. Yeah, we did that. Okay. Did we do Christian Chinchilla Riano? I don't think we did. Yeah, we did. Okay, we did that, didn't we? Chile
Yes.
Riano.
Close, yes.
Makes me hungry just thinking of that. Okay, Melody Cook.
She's at Lakes Crossing, so I don't know how the court wants to deal with this case.
Oh, let's, no, I don't know. When's she going to get out of Lakes Crossing?
I don't even know why she's there.
Yeah, okay, why don't we do this? Let's continue it a week, see if she appears, and if not, then we will reset the sentencing. Does that make sense?
Yep.
Okay. Okay, Martha, give us a date next week. Give us a date 2 weeks out. It'll be out of custody.
Can you give me a minute?
I'm here. I don't. Do I just? Can I hand it to you through the vision? I'm sorry. Yeah, go ahead. I was trying to think of something stupid, which is not difficult for me. Is the marshal there?
You got Deputy Arenas today, Your Honor.
Yeah. Okay.
So next Wednesday, the 21st?
Yeah, go ahead.
Okay, she's
we
set for the next Wednesday.
Can we do an order to Lakes Crossing? Is that possible, Martha?
Okay, so do you want to see her in custody or?
Yeah, let's see her in custody.
I mean, do you want to see her in videos or?
Yeah, see her in videos.
Okay, so the 21st.
Yeah. Okay, we good? Okay, let's go to Alicia King.
Good morning, Your Honor.
Good morning, young lady. Do you admit failing to appear on December of last year?
Yes, sir.
Okay, what's your plea to the battery charge?
Your Honor, we're set for sentencing.
Oh, is this sentencing? Okay, go ahead. Okay. Go ahead, Irma.
Thank you, Your Honor. We expected the victim to join us. Ms. Carrillo is a victim on Zoom?
No.
Okay.
Is that what's is her name Renee?
Yes.
No, it's
Okay.
Oh, yeah, it is. Yeah.
She was saying she was not able to attend the meeting.
Okay.
All right,
So
go
she didn't
ahead.
ask us to wait or anything?
No.
Okay, thank you. Your Honor, Ms. King pled to a simple battery a few days ago. She had been drinking. The date of offense, this offense occurred in June of 2025. As far as what happened, the victim in this case, who is a USPS mail carrier, was delivering mail to the defendant's home. And while the defendant was in her front yard, the defendant's dog charged at the victim. The victim asked for the defendant to put her dogs away so she could safely deliver the mail to her house. The defendant refused. The victim walked across the street to remove herself from the situation. The defendant followed her, being aggressive towards her. She put her hands on her, chest pumped her 2 times, and sprayed her with pepper spray. Miss King is 53 years old. She had an active criminal record in the 90s, but her last entry was in 1998. Of note, though, she's currently being held on a destruction of property from Reno Justice Court. So she failed to appear in our case, gets picked up on a new case on January 9th of this year.
She's having a rough go at it. Her dog attacks the mail carrier. She chases after the mail carrier and pepper sprays them. Yeah, that's a good way to ensure your packages show up on time. And then catches another case for destruction of property. And I don't know if y'all saw her. it definitely looks out of character for this gal. So she has started herself down the beaten path.
Your Honor, this picture to me, and she had been drinking on the date of offense. So this picture to me shows somebody that is struggling, and she had a long period of no criminal activity, but now she's engaging in this type of behavior. So my first thought here is if Ms. King, she's clearly struggling with substance use, wants to get help, maybe a specialty court would be good for her.
As in, you wonder how she's not in prison at the moment? That's what I got.
With a no contact order with the victim, of course. If she's unwilling to do that, I'm going to ask for a suspended sentence in a substance abuse evaluation that she'd be required to comply with that, a no contact order. I'm going to ask that she be required to test with the court post-conviction because she hasn't been testing, and she needs to prove to the court that she can stay sober, obey all laws, and no drugs and alcohol during the suspended sentence. And like I said, alternatively, if she really wants to get a handle on this issue, a specialty court may be appropriate for her. Thank you.
All right, Patrick.
Yeah, she has that Reno Justice Court case that she received an OR on. I'm assuming that they're going to be testing her on that case. I would ask the deputy to confirm that. I believe going forward with this case with a suspended sentence would be appropriate. If she's going to seek help, it will be through Reno Justice Court, their program. She's 53 years old. Her criminal history is not significant. Again, it's dated. She's been in custody for 6 days now. She's currently retired. She was a special ed teacher for the county, and she does have a stable place to live, and she does have a husband. Unfortunately, she has that new case where she'll seek services if she needs them through that case.
Why is it always teachers? Why? Why do we see so many teachers? Teachers and nurses. I don't get it.
Okay. Anything you want to say, young lady?
Not particularly.
Okay, this is what we're going to do. On the failure to
with everything, but
on the failure to appear, I'm going to give you time served. On the battery charge, I'm going to give you 30 days, Washoe County Jail. That is suspended for 1 year. What you're going to do is you're going to report upon release. You're going to be placed on enhanced supervision for 45 days. Obey all laws and no contact in any regard with Renee Archie, Archie. Do you understand?
yes, sir.
All right, that'll be the order. Thank you. Listen, motion on Tibby Miguez.
Thank you.
And he refused.
Oh, okay, let's bump it a day. No bail hold.
Judge, he's not competent.
Oh, okay. Go ahead, Irma.
1 second.
And while she's doing that, Miss Marshall, I have a question for you.
Go ahead, sir.
All right. What do you call a bear that doesn't have any teeth?
A bear that doesn't have any teeth.
Did you say gummy bear?
Yes, I think she said that.
Oh my God. Okay, take the rest of the day off.
Thank you, Your Honor. On Mr. Miguez, he's got an evaluation dated December 31st. The evaluator finds that Mr. Miguez does not meet the criteria to be considered competent. We're looking at a trespass here, that he does appear to be a candidate for civil commitment, that he's unable to care for himself, and would benefit from admission to NAMS for further treatment. Your Honor, based upon that finding, I would request that the case be dismissed without prejudice and request that the jail consider doing a legal 2000.
Okay. All right. Is that it? Is that the calendar?
Yes, Your Honor, that's the calendar. I love Judge Draculich. He is one of my absolute favorites. He's so funny. He's always trying to come up with, little quips on right off the cuff. And there was one hearing I played with him that the husband and wife got into an argument, and like the husband or the one of them's glasses got broken, and the judge was like, he didn't want to make a spectacle of himself. And he had like four eyesight related or glasses related jokes that he threw out there. Like, he's just so funny. Yeah, he definitely does. He takes really good care of his community. He's from Reno. Yeah, there's a video that I have of his that I did with him. King of Dad Jokes is what I think I called it. I'm looking. Nope. Oh, helps if I hit show all, maybe. There we go. Judge Dad always has jokes. Shareable link. Paste. All right. So I put it in the comments. I wonder, is it too late? Yeah, it's probably too late for me to set this up to automatically route. Let me look. Hold on, I might have a trick. I might not, though. Let's see here. No. Ooh, redirect. Oh, huh. It doesn't let me redirect to non-live streams, I guess. Weird. Anyways, I'll put it in the description so you guys can go back and watch it because it was hilarious. It was one of my favorite ones. He was so funny. He's always so funny. Hello, Mortimer Duke. I don't know if I said hi to you yet or not. I think I have a Ricky. Hello, it's a Chris thing. It's not out. It's not edited. Let me see here. Because let's see what he's done recently. Let's see, PHC docket, that was Satterfield. Did Ricky do the first appearances? No. No. There's a Oh, warrant to show cause docket.
Garrett. It's case number 2024 CR 324. James Watts appears as counsel of record for the defendant. Amber Norris appears for the state of Kansas. There's no appearance by Mr. Garrett. The court has received information earlier today that the Missouri Correctional Facility, which is currently housing Mr. Garrett, did not receive information regarding this hearing in time to be able to arrange for Mr. Garrett's appearance. Therefore, it's going to be necessary to reschedule his warrant to show cause hearing to the January docket. I will announce that hearing date and time as Friday, January 30 at 2:30 p.m. Again, January 30th, 2:30 p.m. It would be our hope that proper communication can take place between our court and the Missouri Correctional System so that they can actually have him available for our hearing. So I regret any inconvenience that causes anyone else that's on this meeting. Is there anything else that you believe we need to take up regarding Brandon Garrett at this time, Ms. Norris?
No, Your Honor, thank you.
Or Mr. Watts?
No, sir, thank you.
Very well. Then we'll move on to another matter on the docket. I do see an individual seated at the Butler County Detention Facility Zoom location. Who do we have there?
Andrew Polson.
All right. Mr. Watts, are you handling that case or is that Mr. Favre's case?
I believe it's Mr. Favre, sir.
Okay. I don't see him on the meeting. Mandy, have we heard from Mr. Favre?
He's in a breakout room
I see.
with Cheyenne Pam.
Okay. Well, Mr. Watts, do you have other business on this docket? Jim?
I don't believe so, Your Honor.
Because I
I'll
think
go off to Judge Satterfield here in about 15 minutes.
Okay. Well, Mr. Favre apparently has both Polson and PAMP, so I can go ahead and release you from the meeting at this time, Mr. Watts, if that's the case.
Yes, sir. Have a good afternoon.
You too, sir. Speaking of Mr. Favre, he now appears. Mr. Favre, the court wants to address Mr. Polson's case.
Okay.
It's the state of Kansas versus Andrew James Polson, case number 2023 CR 481. Mr. Polson appears from the detention facility Zoom location. Amber Norris appears for the state, Joseph Favre's defense counsel. Docket notes indicate that Mr. Polson's case came before this court on December the 5th. At that time, he waived a hearing, stipulated the violations. There were conflicting recommendations. The state had recommended a dip sanction. And then Mr. Favre requested an outright revocation. There was a discussion over 131 days of jail time credit, but the matter was continued to today's date. Counsel, what is your position, Ms. Norris, regarding current state case status?
Your Honor, it's my understanding that we just needed to complete disposition on the warrant to show cause. I had notes about looking back into jail time credit. As of today's date, according to our jail, he has 157 days. I did talk to Sedgwick County, we got a hold of Sedgwick County, and he was being held on City of Wichita, Sedgwick County, Marion County, and Butler County, either warrants or charges from September 29 to October 28. So that's 29 days. And it's my understanding that he has cases pending in either Wichita and Sedgwick County, and then the Marion County case is still pending.
All right.
So he has 157 as of today's date directly from our jail. And then depending on how the court decides, I guess possibly 29 days. But like I said, he was being held on 3 other jurisdictions besides Butler.
All right.
For that
Has your
time.
recommendation otherwise changed, Ms. Norris?
The position regarding the final disposition of the warrant. Your Honor, this was his first warrant to show cause. He was sentenced March 7, 2025. I believe he basically didn't really report, and so the warrant has been outstanding since March. So no, Your Honor, I don't think that the state's position has changed. He doesn't need an extension. This was an SB 123, so it's up to 18 months. I don't know that I have any additional information to add to that, Your Honor.
Thank you. Mr. Favre, on behalf of your client, what is your position today regarding case disposition?
So, Judge, Ms. Norris accurately recites where we were. I will note that I've since our last hearing gone back and reviewed his jail credit, and I concur with the jail, given that he's been in that jail 157 days. I've also reviewed the Irvin case, which I recently reviewed, which says that basically anything that he got credit for where there was a hold in another, even if it was double time, I think he would get credit for that 29 days. So I think he's entitled to a total of 186 days of jail credit, if my math is correct, altogether, because of that extra 29 days, because he did have a hold out of our county. And the Irvin case basically says that the statute prior to the legislature amending it in 24 should have given jail credit for any time where the person was held in custody, period, even if it means that double credit is given. The statute was amended in 24, and the new statute doesn't seem to preclude that credit for Sedgwick County being given to him either, because the statute language only excludes credit for time spent in another jurisdiction, in this case Sedgwick County, where no hold was issued. But as Ms. Norris stated, there was a hold issued from Butler County, so I think he would get credit for that additional 29 days. So our request is, he has the 8-month underlying sentence. I know he's looking just to have this behind him, so I think we would renew our request to just have the court impose the underlying sentence, give him credit for his 186 days of jail time credit, which would 8 months times 30. He's got maybe 60 days left, give or take, the jail time credit the good time credit he would get. So that would be our request today.
And
So you
Your
just
Honor,
get-
I think if the court was to grant that, the court's gonna have to make special findings because he's not had a dip, so the court obviously can make those findings that he's, not amenable to probation. And Your Honor, regarding the Irving case, there is a case that came out after that State v. Mitchell. It's a Court of Appeal case that it applies only to sentences for crimes committed on or after May 23rd, 2024. So the court would, I guess, have to decide whether or not that even applies to this case based on date of offense as well.
Well, the date of the offense here, the case was filed on October 6th of 2023. So it obviously was committed prior to that point. Court wishes to address the defendant before any further rulings are made. Mr. Polson, you've been present, you've heard what the attorneys have recommended and stated to the court. Do you have any statements that you wish to make in mitigation of punishment here?
No, sir. I just want to make sure I'm credited for what I've done already.
What was the last date that you were out on the streets, Mr. Polson? Do you remember?
September 22nd, 21st, maybe.
Okay. So you've been locked up continuously for over 3 months?
Yes, sir.
Man, if I was locked up, that date would be etched in my brain. There would be no 22nd or 21st, maybe. No, I would know it by heart when the last time I saw sunshine was.
Very well. I will note and remind everyone as to what Mr. Ketley's allegation was in the warrant to show cause. At defendant's sentencing, March 7, 2025, he was instructed to contact Community Corrections upon his release from custody. The defendant was released on March 10, 2025, which this court will interject 3 days later, and failed to contact our office. The defendant's current whereabouts are unknown. And I think this was submitted to the court in October. Actually, he swore to the affidavit in March of 2025. Apparently, it took a while to get Mr. Polson back before this court. This court finds that failing to report at all is deliberate noncompliance with the terms and conditions of the court's original Senate Bill 123 orders. His failure to report indicates that he's not amenable to probation. The court will, at this time, order outright revocation of Andrew Polson's probation in the case, noting that he himself requests that the court make that order. He apparently recognizes himself that he's not a probation candidate in this case.
Well, it just means that he knows he doesn't want to follow anybody's rules.
That's all. I'm looking at the original sentencing journal entry in this case for just some additional information.
Yeah, for sure. Good night, Purple Kiv.
Court will find it again at this time that it's not in the best interest of this offender to be placed on a probation in which he's highly likely to be unsuccessful. Court feels that that would be a waste of community corrections resources. The court will grant this defendant 186 days of jail time credit. This court is not assured that he will receive proper jail time credit for this time actually incarcerated, if not granted in this case. Court doesn't want to see dead time. Mr. Polson is awarded 186 days of jail time credit.
I don't think Judge Ricky likes that.
Does Mr. Polson have other holds on him?
Yes.
Your Honor, he has a hold out in Marion County for certain. I'm
And-
not sure whether or not Sedgwick County or City Wichita have a hold, but
Okay.
Marion County still does.
What is the Marion County hold all about?
I don't know what the charges are there, Your Honor, but
Mr.
he
Polson,
had
can you
that.
fill the gap?
It's actually Morris County. Morris County, not Marion.
Okay, what are you facing there?
Cultivating marijuana charge.
So that's just a pending case that hasn't been
Yes, sir.
resolved yet?
Yes, sir.
Well, this court notes that the defendant has served more than 6 months sentence in this case. The court deems that to be an appropriate penalty for his crime in this case and failure to meet probation conditions. This court will, under KSA 223716, modify the sentence to 186 days. Credit 186 days of jail time credit and flatten that sentence. Since he did not go to DOC custody, the court does not believe that post-release supervision would be appropriate. And that would then mean that Mr. Polson, he's certainly not going to be released. He's now going to face going to apparently Morris County.
Yes, sir.
To face a serious drug charge, and his status can be determined by the Morris County Court when he arrives there. Court will not be assessing any additional amounts on the case. Anything he previously owed is still owed and can be sent to collections at this point if it hasn't been already. All right. Court has made its orders in the case, but Ms. Norris, do you need any further clarification from the court?
Don't believe so, Your Honor. Thank you.
Mr. Favre, are you aware of anything else that needs to be addressed?
No, Judge, thank you.
All right. Mr. Polson, you're apparently on your way to Morris County. I regret that you weren't more successful in this case and had to serve over 6 months of your life in jails. Nevertheless, you're essentially released from any further obligation in this case, except for your financial obligations. And I'll just point out that if it goes to collections, you'll have additional amounts added to what you already owed the court.
Yes, sir.
All right.
Thank you.
If there's nothing further, then the Andrew Polson matter will be in recess at this time. We'll move on to another case. Cheyenne Pam.
Yes.
Court will call the case of State of Kansas versus Cheyenne Lee Pamp, case number 2024 CR 537. Cheyenne Pamp appears at the court security Zoom location located at the Butler County Judicial Center. Brett Sweeney appears as prosecuting attorney for the state. Joseph Favre appears as defense counsel. Court has before it the warrant to show cause, alleging probation violations, failing to report as directed, failing to enter a Senate Bill 123 alcohol and drug treatment program as recommended, failure to complete a mental health evaluation, failing to attend MRT as alleged by Ms. Ashenfelter from Community Corrections. What are your client's intentions, Mr. Favre? Mr. Favre?
I'm sorry, Judge. I must have cut out there. I didn't hear your request. At this time, Ms. Pamp is. Oh, hold on. Can you hear me?
Yes.
Okay, good. Ms. Pamp is going to waive her right to an evidentiary hearing and stipulate to the violations.
All right. Ms. Pamp?
Yeah.
Respond verbally, please.
Yes.
Okay. You've heard what your attorney announced to the court?
Yeah, to waive the right.
Okay. You do have a right to a due process hearing where the state would have the obligation of proving these allegations by a preponderance of the evidence. You would have the right to challenge the state's evidence, confront their witnesses unless good cause was shown, present your own evidence, of course. And I do want to make sure you understand that among other lesser remedies, the court could consider just an outright revocation of your probation and having you serve the remaining balance of your sentence locked up. Do you understand these things?
Yes.
Do you waive a hearing in this case and stipulate and agree that you committed the violations which the court outlined earlier?
Yes.
All right. Court finds that the defendant Pamp has knowingly and voluntarily waived her right to a hearing and stipulates and agrees that she's committed the violations as the court has stated on the record earlier. Court does find that these are substantial and material violations of the terms and conditions of her probation. And I will note that her original sentence was for possession of methamphetamine with an 11-month controlling Department of Corrections sentence. Court will now turn to disposition in this matter. Mr. Sweeney, on behalf of your office, what are your recommendations?
Thank you, Your Honor. Your Honor, the state is recommending a dip sanction, either the 2 or 3 day variety, but I would recommend and think it's appropriate that that be served prospectively from today's date. Ms. Pamp, this is a Senate Bill 123 case. Ms. Pamp was placed on community corrections probation on October 7th, and she had a warrant for her arrest by November 13th. So a little over 30 days. Basically, she just didn't really even start, it doesn't look like. So I think that's appropriate. And then certainly I don't think she needs an extension, but would recommend that she be placed back on community corrections probation with the same and previously ordered conditions, and then would ask the court to take a look at additionally assessed fees.
Thank you, Mr. Sweeney. Mr. Favre, your recommendations regarding an appropriate disposition here.
Thank you, Your Honor. A few things. I think, first of all, Mr. Sweeney's accurate regarding the quick time that it took Ms. Pamp to fail to report. I would note that Ms. Pamp experienced the death of a very close relation, and that is not a justification exactly, but it is something to consider. That is part of what caused her to spiral out and miss her appointments. I would note that at the time of sentencing, I think she was eye-boxed. She doesn't have much exposure to the criminal justice system, and she has since that time gotten back in touch with Ms. Ashenfelter and has reported at least twice from what I've been led to believe. So she also tells me she has an appointment set up with South Central Mental Health. I think she said tomorrow for a possible mental health screen. And so I think a 2-day dip is appropriate. We'd ask the court to consider allowing Ms. Pamp to do that scheduled starting next Friday. She can report next Friday. That will allow her to clear her appointment with South Central and be ready to go.
Okay. Mr. Favre, you froze up.
26 days already from the warrant return until she.
Okay, Mr. Favre, you're cutting out.
Yeah, I'm in court.
I'm supposed to be there too.
Okay, sorry.
Anytime you have to just report in, because otherwise, I think it's if she goes to jail and you'll know it, she walk out of here.
Okay.
Okay, what's going on at court security?
Now that she didn't advise me when she was done with her attorney, so.
Okay, well, her attorney was cutting out. He had a presentation he was making to the court, which essentially you may have to start over, Joe. What?
Okay, sorry. So Judge, essentially, Ms. Pamp, limited criminal history. She came in with almost none. She did experience a traumatic death. None of that justifies, of course, her failing to report so quickly, but she has since reported to Ms. Ashenfelter twice, from what I've been led to believe. She also currently has an intake schedule with South Central Mental Health to do a mental health intake tomorrow. So we think a 2-day dip is appropriate, even though she's already done 26 days when she was originally arrested on the warrant to show cause. But we would ask that she be allowed to schedule that for next Friday so she can make her appointment with South Central and be ready to turn herself in next weekend.
Thank you, Mr. Favre. Ms. Ashenfelter, on behalf of the Community Corrections Department, do you have any additional remarks or suggestions for the court?
No, Your Honor.
All right, thank you. All right, Ms. Pamp,
Yes.
I'm going to address you personally and ask you if you have any statements that you wish to make in mitigation of punishment here.
No, that I think he pretty much summed it all up,
Okay, well, yeah, he summed it up, but I still don't understand it. Why is it that you don't want to do probation? Why haven't you made more effort to work on the requirements of your probation instead of just blowing them all off?
I'm not trying to blow anything off, sir. In my defense, like I'm just now like learning to do things the right way, and it's not easy, and I am trying. I'm trying really hard. I struggle with addiction
I don't know
every
what you
day.
mean by trying really hard, because you haven't tried to do anything right in this case.
I've been reporting. Normally, whenever I get out, I don't even report. I just immediately go on the run. I've been reporting. I've gone to South Central. I'm actually starting to go to NA and AA. So I'm sorry, sir, if you believe that I'm not, but I know the effort I'm putting forth. And I know it's more effort than what I've ever put in my whole entire life towards
I trust
this.
that you started reporting after this warrant to show cause issue.
I seen her twice last time as well.
Ms. Ashenfelter, is that correct? Lately, she's doing better with reporting?
Yes, Your Honor. I've seen her twice since she was picked up on this revocation. she's putting forth an effort from what I can show, more than she was before. Time will tell how she will do.
All right. Anything else, Ms. Pam?
That'll be all.
All right. As a sanction for noncompliance for the probation violations, which the court previously found to be substantial material, the court will order this defendant to serve a 48-hour, in other words, a 2-day dip, effective immediately. I note Mr. Favre's request to allow her to defer that to some future date. The court's not inclined to do so. Ms. Pant, because of your noncompliance, you forfeited your New Year's celebration as far as the court's concerned. And the court's going to order you into immediate custody to serve 48 consecutive hours without release privileges. We call a 2-day dip for being released back into the community, back on community corrections probation to complete any unsatisfied condition which still remains. The court will not be assessing any additional financial amounts at this time. However, anything previously assessed is still remains owed and needs to be paid in the manner that was originally directed, which I think was $75 a month. Ms. Ashenfelter, do you already have a future appointment with Ms. Pamp?
Yes, Your Honor, we do.
Okay, what date and time is that? I want to remind her.
It's the 7th.
Yes,
Okay.
she's set up to come in right after MRT group.
Okay. So she'll be attending group and then coming in to see you?
Yes.
Okay. You know what that's all about, Cheyenne?
Yeah.
Okay. All right. Well, I'm placing you into custody
Okay.
for 2 days before you can be released back into the community as a sanction for your previous noncompliance. I truly hope that you're successful with all aspects of your probation program in the future so that the court doesn't have to review your sentence again in the future.
Yeah.
All right. Mr. Sweeney, anything else we need to address here?
No, Your Honor.
Mr. Favre?
No, Judge, thank you.
Any further clarification needed, Ms. Ashenfelter?
No, Your Honor, thank you.
Okay. Then court places Ms. Pamp in the custody of the Butler County Sheriff's officers until she can be transported to the Butler County Jail to serve the 48-hour sanction period, the 2-day dip, which the court has imposed here today. If there's nothing further, the Pamp matter will be in recess. Counsel, this would appear to complete the cases on this docket. Do you agree, Mr. Sweeney?
Yes, Your Honor. Thank you.
Mr. Favre?
That's all I have, Judge.
Very well. Then that will conclude the docket at this time.
And this meeting may be ended for all. Oh, I don't doubt that a bit. The fact that she's still using, well, I'm struggling with addiction so freely like that, she's not ready to give it up. Yeah, they're both resting peacefully. Billy's given himself a bath. He's really testing the strength of that donut bed there. You can hear it crunch as he climbs on it, as it buckles beneath him. Well, she said that she normally just bolts right away. And this time she's trying really hard because she attended twice. So hopefully we're wrong about her. She says she's doing the AA and NA. Hopefully she gets it together and is successful. Yeah. And that's usually the case with the ones that we see that are not successful, is they're far too prideful. All right, guys. I don't have a microphone that I can do that with. And I've never heard of BCNN. My microphone is a big blue Yeti, so I don't have one of those little ones with the fur balls on the end of them. You're welcome. I did Ricky just for you. I got a couple Ricky sentencings. I should go through and see if I have the rest of the hearings for FTCs for him. I've never heard of it, but it sounds interesting. All right, guys. I'm gonna, listen to that. Hi, Billy. Hey, Billy. Billy, have you had too many treats, baby? Billy, how many treats have you had? The bed is struggling, buddy. Oh, I love you so much. Well, there's more to his name. Boner. Yeah, I caught that the last time that he was in chat. I was like, B1R. Oh, yeah, I know what that means. Why, thank you. I happen to love them. Earl's pattern is so unique. Right now it looks like he's got a perfect arrow on his back or side. It is a perfect arrow. That is so cool. I can't wait to show my daughter that. Oh, Earl is the cutest thing ever. All right, guys, thank you so much for coming and hanging out with me. I had a great time tonight. Be safe, be well, sleep sweet, and much love.